Hello Paddocks Club members, my name is Jennifer Clements. I'm coming to you from Victoria in Australia. I'm actually Graham Paddock's daughter and used to work at Paddocks for a few years and have come over to Australia, been living here for the last 2 years, working in Strata Title, which is the equivalent of sectional title in South Africa. So we thought it might be interesting to do a bit of a kind of comparison in terms of some of the sections in the Sectional Titles Act with some of the sections in the Owners Corporation Act, or actually look at some of the prescribed management rules and compare them to some of the sections in the Owners Corporation Act. And it might be quite interesting for you just to see from a comparative point of view how things differ from one country to another, and also the fact that the Sectional Titles Act in South Africa is actually largely based on the New South Wales legislation, which is Australian legislation, and so is the Victorian legislation, which I'm working with at the moment. It's also largely based on the New South Wales legislation. So there are very much, there are some similarities between the two acts of the Victorian legislation and the South African, but there's also some differences, and what I see as slightly more progressive in the Victorian legislation, which I think may be interesting for you to hear about, and who knows, one day may apply in South Africa. So what we're going to talk about today is quorum requirements for general meetings, so meetings of bodies corporate as a whole, not just trustee meetings, and what happens when there is a lack of attendance at those meetings and therefore a quorum is not present at the general meeting. So in terms of prescribed management rules 57 and 58, so obviously we're talking about the South African legislation now, if there's 10 units or less in a sectional title scheme, you need 50% of owners represented in number and value. If there is between 11 and 49 units in a sectional title scheme, then you need 35% in number and value represented to form a quorum. If you have 50 or more units in a sectional title scheme, then you'll need at least 20% in number and value to be present in order for the meeting to take place. Now, in terms of the prescribed management rules, actually prescribed management rule 58, if one of those percentages is not met, depending obviously on the number of units in the scheme, then what happens is the meeting waits for half an hour. So say the meeting's at 5 o'clock on a Wednesday. If within half an hour after 5 o'clock the required percentage of owners in number and value is not present, then we adjourn the meeting in terms of prescribed management rule 58 to the following week, 7 days later, at the exact same time and place. And if at that meeting we still don't have a quorum, provided there are 2 members present, then the meeting can go ahead and then resolutions can be made and it moves on from there. Now, it's completely different in terms of the Owners Corporation Act in Victoria. So basically, Owners Corporation is another way of saying a body corporate. So they actually used to be called bodies corporate here, but have just recently changed with the new Owners Corporation Act, which has come in and it's changed the terminology. Anyway, that's a side point. So basically what happens here is that regardless of the size of the scheme, we have a 50% quorum requirement. So 50% of owners in number and value, or number or value actually, are required to form a quorum, regardless of whether you have a scheme with 2 units or if you have a scheme with 102 units. It doesn't matter, 50%. So there's none of this 50, 35, 20%, depending on the number of units in a scheme. And what happens here is that if you call a meeting, and as often happens in community schemes, owner apathy kind of creeps into it, and you don't have a quorum present at the time of the meeting, then here you can actually proceed with the meeting, okay? It doesn't matter if one person rocks up with the manager, or if it's, just 2 people and, the scheme is so big that it actually would require 50 people to be present because it's a 100 lot scheme or unit scheme. Sorry, different terminology again. What happens here is that we can proceed with the meeting regardless of the number of people present. Obviously, in terms of probably common law, you're not going to have a meeting with one person. So if it's just one owner rocking up on his own and there's no manager present, that meeting can't really be called a meeting. But say there's 2 or more, you can still go ahead with the meeting because we have Section 78 of the Owners Corporation Act. And basically this section tells us, well, I'll read it to you, but basically what it says is that regardless of the fact that a quorum is not present, the owners present can proceed and make what they call interim resolutions. So they can go through each item of the agenda and resolve whatever they please, going through each item. But those resolutions are not actually resolutions of the owners corporation or the body corporate until 29 days have passed after the meeting. And the reason for that period is that straight after the meeting, the minutes have to be sent out within 14 days. So if it was just you and me that rocked up at the meeting and there's 48 other owners that weren't there, we prepare the minutes and we send them out to owners within 14 days, and those owners then have 29 days in which to object basically to the resolutions that we made. If they do object, what happens is we have to call a meeting, and then the resolutions have to be confirmed at that meeting. But 99 to 100% of the time, in my experience, nobody does object, because if the owners are kind of in that apathetic mind state where they're not coming to the meeting in the first place, they don't really kick up a fuss about what happens at the meeting because they're not particularly interested. So we do the meeting, we make interim resolutions, we send them out to all the owners, 29 days go past, and provided nobody objects, those become the resolutions of the owners corporation and they can all be acted upon. So in effect, what happens is the resolutions or interim resolutions made at the annual general meeting or a special general meeting are suspended in the sense that they can't be acted upon for 29 days, and after that period of time, provided that there's been no objections and no meeting has been called to reconsider those resolutions, then we can act upon them as if they were resolutions made with a quorum present. So I think that's a really progressive and great, great section to have in the Owners Corporation Act. I think it's very useful for myself as an Owners Corporation manager here. It's a godsend. So yeah, I just thought that we would share that with you and hope that you found that interesting. There also are a number of other clauses and sections which I think are also very good. We also have interim special resolutions. Our unanimous resolutions are different as well. There's things with, there's so many things that we could talk about actually, but that's probably enough for today. So I hope you've enjoyed that, and if you have any questions, pop them on the forum. I can't guarantee that anybody in South Africa will be able to answer you, but perhaps I'll be able to answer you. So have a good day and thanks for listening. Cheers.